My friends, welcome to tonight's Stevenson Trust Lecture. It's my very great pleasure to welcome attendees here in the Charles Wilson Lecture Theatre, and also I get to echo Nicholas Parsons when I say this, our listeners from around the world who are tuning in via the magic of Zoom. You're all very welcome indeed. My name is Ben Coburn. I'm Professor of Political Philosophy at the university, and it's my great privilege to chair today's proceedings on behalf of the Stevenson Trust for Citizenship. The Stevenson Trust was established in 1921 with a gift to the university from Sir Daniel Stevenson, Chancellor of the university at that point. He provided the gift for the education of the people of Glasgow on matters of citizenship, local, national, and international. The public lecture series that the Trust runs is one of the ways that we look to fulfill that remit. Another way that Sir Daniel probably wouldn't have been able to envisage is that we now put the materials from these lectures online. So please note that this event is being filmed and will be made available via the video archive on the Stevenson website. We take your presence here as consent to that and ask your questions with that recording in mind, please. Finally, another little bit of housekeeping. We're not expecting a fire drill during this event, so if the event goes off, please follow the green signs to the nearest exit. You might find yourself mingling with the St. Patrick's Day revellers looking to get into the hive across the road. I think the soundproofing in here is pretty good, so they're not going to disturb us, but forgive our celebrating students at the end of their semester if you hear a little bit of noise outside. I want to say a little bit about Dudley Knowles. This is the 9th Dudley Knowles lecture in political philosophy. Dudley was a political philosopher who taught in the Glasgow department from 1973 to 2011. He published widely on topics including the philosophy of Hegel and the history of that figure, the theory of rights, and the foundations of political obligation. We remember him as an accomplished scholar and also as a great teacher and a kind and wise colleague, including as head of department on 2 separate occasions. He was also a member of the board of the Stevenson Trust for many years and was deeply committed to its mission of putting the insights of academia to work in the public interest. So it seemed fitting, after Dudley died in 2014, for the Trust to commemorate him with an annual public lecture, where we invite an eminent philosopher to use their craft to tackle a topic of public interest. In that connection, we're delighted this year to have had our invitation accepted by Professor Qasim Qassam to deliver the lecture. Professor Qassam is Professor of Philosophy at the University of Warwick. He has also worked in the past at Cambridge and UCL and Oxford, where he also pursued his undergraduate and doctoral studies. His work spans a very wide range of topics within philosophy. His earliest publications were on the philosophy of Immanuel Kant. He then moved through self-knowledge to focus his attention on the theory of knowledge, where his extremely important 2007 book, The Possibility of Knowledge, was a key driver of a contemporary renaissance in epistemology. That is, by the way, only one of 7 monographs that Professor Qassam has published, alongside myriad articles, edited volumes, and other contributions to our shared enterprise. In more recent years, Professor Qassam has turned his attention to more topical matters, and he has published books on intellectual vices in politics, on conspiracy theories and extremism, and is currently co-writing a new book on terrorism. His ideas about these important and urgent matters have not been limited to the academy. He's in great demand as a contributor to the print and broadcast media on these topics and brings some very welcome and needed rigor and clarity to these heated matters. I'm really delighted that Professor Qassam is bringing this experience and commitment to public philosophy to us in Glasgow today. to deliver this year's Dudley Knowles lecture on the topic Defining Terrorism from Emily Davison to Axel Rudakubana. So please join me in giving him a very warm welcome indeed. Thank you, Cassie.
Right. Well, first of all, thank you very much for the invitation to give this lecture. It's a huge honor to be giving the Dudley Knowles lecture. And one of my missions recently has been to connect philosophy with topics of a wider interest. So today's topic is the definition of terrorism. And I'll start off with a little anecdote. I was at a conference a couple of years ago on the definition of terrorism, and the participants were a mixture of people in terrorism studies, the odd philosopher, namely me, and interestingly, also people from the world of counterterrorism and the intelligence community. And one of the very senior intelligence people who was there said something in discussion, which he's also said in print, so I feel comfortable quoting it. He said something like this: in 25 years working on counterterrorism, I can't remember any serious discussion of the definition of terrorism. So it was interesting that from the sort of practitioner's point of view, the questions that preoccupy terrorism scholars are much less pressing and much less urgent compared to the issues that really are urgent for them, which is countering terrorism. So I'll start off with that observation. Okay, so I think if you were to ask a practitioner, well, what do you think terrorism is? How would you define terrorism? I think one thing that many of them would say is, well, terrorism is just what the law says it is. I mean, that's all we need to say for our purposes. So obviously terrorism in the UK is what the law in the UK says it is. Terrorism in Russia is what the law in Russia says it is, and so on. And if you are interested in the question whether a given act is an act of terrorism, you just need to consult the definition. Now, of course, in the UK, the definition of terrorism is contained in the legislation, the relevant legislation being the Terrorism Act 2000, which has been amended in various ways, but that's the basic framework for thinking about terrorism. So when Parliament passed the Terrorism Act 2000, what Parliament was doing was exercising what some people call definition power, the power to define a term and to, as it were, stipulate a meaning for the term. So legislators have definition power, but other people also have definition power. The general public does, actually. Politicians do, journalists do, and you then get conflict sometimes or disagreement when people exercise their definition power in different ways and have slightly different conceptions of what terrorism is, and this then results in debate and disagreement. So a very interesting recent case, which of course you will know about, is the case of the Southport murders. So I take it I don't need to go into much detail about that, but you'll know that the person who pleaded guilty for the murders of 3 young girls in Southport was Axel Rudakubana, whose murders were extremely brutal, involved extreme acts of violence. But Rudakubana was not charged with terrorism. I mean, he was charged with possessing a terrorist manual, but the murders were not charged as acts of terrorism. And the justification for that was that according to the law, according to British law, he didn't meet the conditions for terrorism. And I'll explain what those conditions are in a little while. But the Prime Minister, Sir Keir Starmer, made a statement about the Southport murders. And in this statement, Starmer is, in a way, trying to exercise definition power. what Starmer was saying in his statement is that while the police may have been right not to charge Rudakubana with a terrorist offense, it wasn't clear to Starmer that that was the right result. So in effect, what he was suggesting was that the law was drawing the boundary between terrorism and non-terrorism in the wrong place. That was what Starmer was saying. Okay, so there's some quotations here from Starmer. Terrorism has changed, he said. In the past, the predominant threat was highly organized groups with clear political intent. But now we also see acts of extreme violence perpetrated by loners fixated on violence seemingly for its own sake. Okay, so these are some two key features of the Southport murders, which Starmer is highlighting. One was that the violence in that case was extreme violence, I mean, unusual in its brutality. And he was also focusing on what he took to be another feature of the Southport murders, which is this was violence seemingly for its own sake, as Starmer put it. And he then came to the key point of his remarks, which was, given the extreme nature of the violence that was clearly intended to terrorize, I understand why people wonder what the word terrorism means. And so in effect, he was saying, well, you know, for most people, the general public looking at this case, they might think, well, obviously this is terrorism. Right? This was extreme violence with the intention to terrorize. Why isn't that terrorism? So the net result of this was that the Home Secretary ordered an urgent review of the definition of terrorism in the light of the Southport murders, and the results of that review were published last week on Thursday, and I'll say something about those results. So the concern that Starmer was expressing was that the definition of terrorism in the UK is too narrow. It's too narrow if it doesn't cover events like the Southport murders. But historically, the concern about the British definition of terrorism has not been that it's too narrow. A much more typical concern has been that it's too broad. So the very opposite of Starmer's concern. So Starmer's concern was that the Southport murders were a false negative for the definition of terrorism. In other words, here was a case that ought to have been classified as terrorism, but that did not fall under the definition of false negative. Right? But historically, a much greater concern is that the UK definition of terrorism actually generates false positives. Cases where something would be classified as terrorism according to the law, but which ought not to be so classified. Okay, so you have this pressure coming from two directions. It's too narrow, it's too broad. Okay, now so this is really what I want to talk about. I want to talk about these concerns about on the one hand, the excessive narrowness of a definition, on the other hand, the excessive broadness of a definition, and then to think more broadly about how you resolve these questions about the nature of definition. And this is where there's a connection with philosophy, because of course, in philosophy, definition is a really, really big subject. Right? And I was really surprised when I started working on the definition of terrorism, how little impact philosophical thinking about definitions has had on that field. And most of the people I speak to in terrorism studies or in the law, it's a real surprise to them to learn that this is really a big topic in philosophy, the nature of definition, right? Whereas those of us who do philosophy obsess about it all the time. Okay, so that's the issue that I'm going to talk about. But before I get into that, let's be clear what the legal definition of terrorism in the UK actually is. Okay, so I assume most people are not familiar with this. So the definition of terrorism is in three parts, basically, or it has three limbs. The first limb specifies the kind of action that it needs to be for it to be terrorism. Okay, so it specifies the means of perpetration for an act to be an act of terrorism. So here's a list of the relevant means of perpetration. Right, so terrorism has got to involve at least one of these things: serious violence against a person, serious damage to property, endanger a person's life other than that of the person committing the action, create a serious risk to the health and safety of the public or a section of the public, or is designed seriously to interfere with or seriously to disrupt an electronic system. Okay, so that's the first limb, right? So for something to be terrorism, it's got to be one of those things. Second limb, terrorism is the use or threat of action that is designed to influence the government or an international governmental organization, or to intimidate the public or a section of the public. And three, the use or threat of action is made for the purpose of advancing a political, religious, racial, or ideological cause. Okay, so just looking at those two limbs, in limb 2, designed here is understood by lawyers to be intended to. That's what designed means. Okay, so it's the use or threat of action that is intended to have a certain influence, right? Or to have a certain effect, namely to intimidate the public or a section of the public. Okay, that's the second. And the third limb is the idea that it's not terrorism unless it's the use or threat of action that is made for the purpose of advancing a cause, right? And the cause must be a cause of one of these four kinds: political, religious, racial, or ideological. Racial was not in there in the 2000 Act, and racial has since been added to, to allow for the possibility of, so for example, white supremacist terrorism. So it's worth just pausing to note just how broad a definition this is. Okay, first of all, this definition does not require terrorism to be violent. Right? The threat of violence, for example, would qualify. But also, if you look at the list of actions, I mean, the last one is in there to cover cyber terrorism. So that isn't violence. Okay, so that's one respect in which the definition is extremely broad. It doesn't say anything about terror, interestingly. Okay, the definition of terrorism does not require terrorism to be terrorizing. Right? So again, you might think of the case of cyber terrorism, right, which needn't it may be very inconvenient. It may be economically catastrophic for the victims, but it isn't required to be terrorizing. Right? I mean, even if you think about bombings and shootings, I mean, somebody who is instantly killed by a terrorist group, they may not be terrified because they've died instantaneously, and it might be distressing to other people, right? Might have an impact on them, but the impact doesn't have to be to terrorize them. Also, the definition doesn't require the targets of terrorism to be civilians. Right? So people often think of terrorism as directed at civilians. Right? This definition doesn't require it to be directed at civilians. Okay, so acts of terrorism where the target is a military target could still be terrorism. Right? And indeed, if you think about 9/11, right, one of the targets of 9/11 was the Pentagon, right, which I take to be a military target, right? But that would still be terrorism by this definition. It doesn't stipulate that terrorism is the work of non-state actors. So this is another interesting respect in which the definition is very broad. Right? So if you read the US Code, there's a title in the US Code that defines terrorism as the work of non-state actors. The states can't be terrorists. This definition does not introduce any such restriction. I mean, as a matter of practice, states are not prosecuted for terrorism in the UK, right? But there's nothing in the definition that rules that possibility out. It also, when it talks about a section of the public, it doesn't set a lower limit to what a section of the public is. So that's another respect in which the definition is quite broad. And lastly, it doesn't require terrorism to have a specific motive, though it does require it to have a specific purpose. So just to explain the difference between a motive and a purpose. So supposing that I go to the gym every day, right, and for me, the purpose of going to the gym every day is to build my muscles up, right? Why do I want to build my muscles up? Well, supposing my motive is actually vanity, right? So there's a difference there between my motive, which is vanity, right, and the purpose of the action, which is to build muscle, right? So motive and purpose are not the same thing, right? And so this says, look, even if a terrorist is motivated by money, supposing they're paid to carry out acts of terrorism, even if they're motivated by money or by the desire for revenge, or by, it doesn't really matter what their motive is. Maybe we'll never know in many cases what the motive is. The crucial question is, what was the purpose for which they were acting? If they were acting for the purpose of advancing a political, religious, racial, or ideological cause, then they are potentially within the framework of the Terrorism Act, regardless of their motive. Okay, so this is a very, very broad definition of terrorism. I mean, it's also worth thinking about the fact that terrorism also includes damage to property. So if you want an illustration of how broad a definition this is, I'll give you a classic example. This is the example of the suffragette, Emily Davison. So in 1913, Emily Davison attended the Epsom Derby. And I will read a description of what happened next. As the first group of horses passed her and a second group rounded the corner, she slipped under the rail and ran onto the track. Newsreel film shows her running towards the king's horse and throwing up her hands, perhaps to stop the horse, perhaps to protect herself. In an instant, woman, horse, and jockey are on the ground. Only Davison was seriously hurt. The horse walked off the track, and the jockey, Herbert Jones, recovered from his injuries. Kicked in the head, Emily Davison died 4 days later without regaining consciousness. Right now, it looks as though this falls under the definition of terrorism. She endangered the life of a person other than herself, so she endangered the life of the jockey. Her action was presumably designed to influence the government. This is what her intentions were, we'll never know. She never regained consciousness, but this seems a reasonable hypothesis about what she was intending to do. And it was an action that had the purpose of advancing a political cause, the suffragette cause. Right? So this looks like it would in fact be an example of terrorism. Right? And yet, as various people have noted, most notably Lord Carlile, in a brilliant report on the definition of terrorism published in 2007, he gives this example of Emily Davison as a case that falls inappropriately, or might be thought to fall inappropriately within the current definition. I mean, there are many, many examples that one can give. Right? So imagine during the pandemic, someone publishing anti-vaxxer pamphlets, right, with the intention to influence the government's policy on vaccinations, and for the purpose of advancing the cause, the anti-vaxxer cause, right, you could think of as an ideological cause. Well, insofar as it posed a risk to the health and safety of the public, that would also be an action of the relevant kind. Indeed, actually, even wars look like they're going to fit this definition, right? So the Russian invasion of Ukraine, well, presumably that meets all the conditions of the definition, as did the Ukrainian military response to the Russian invasion. Okay, so now the worry is that this definition is so broad, that it's actually going to cover not just what you and I might think of as acts of terrorism, but also certain kinds of political protest. Right? Chucking paint on masterpieces, right, might qualify. So if you say, well, okay, in what sense does the definition count people like Davison as falling inappropriately within definition? The thought would be, well, it just doesn't seem right. It doesn't seem right that this such a wide range of actions should count as terrorism. So a natural thought a natural thought confronted by these cases is, well, maybe the definition needs to be tightened. But if we don't want it to be so broad, maybe we should tighten the definition. Okay, so that's one side. And then there's the other side, which is the Rudakubana case. Right? So this is the other side where you have people saying, well, no, we don't need to tighten the definition. We need to loosen the definition to broaden it out so that we are actually able to get people like Rudakubana within the definition. And so the reason that Rudakubana was not charged with terrorism was that he didn't meet the third limb, or it was assumed that he didn't meet the third limb. So just to remind you of this, the third limb is action for use or threat of action for the purpose of advancing a political, religious, racial, or ideological cause. The police judge, the Crown Prosecution Service judged that he did not act for the purpose of advancing a cause of any of these sorts. That's why he wasn't charged with terrorism. So along comes the Prime Minister and says, well, that doesn't seem right. Members of the public will look at this and think, surely that's terrorism. Okay, so one way to deal with this case is just to drop the third limb. Should we do that? Well, if you drop the third limb, then of course you've really got a real explosion now of potential false positives for the definition of terrorism. I mean, what we want, of course, is a perfect definition, right? A definition that hits the sweet spot. Right? We want a definition that doesn't count too much as terrorism and doesn't count too little as terrorism. We want a definition that just draws the line in just the right place. But of course, there are very good reasons. I mean, for philosophers who are listening to this might think, well, there are actually quite good reasons for thinking that you're never going to get a perfect definition. Right? You're never going to get a definition that does that. I mean, we want to get off the seesaw. Right? You've got the positives and the negative, the false positives and the false negatives. We're on this seesaw. We want to get off the seesaw. The way to get off the seesaw is to come up with a perfect definition. Okay? But there are actually some good philosophical reasons for thinking that we're not really going to get such a definition. So here are a couple of quotations that will be familiar to philosophers in the audience. One is from Jerry Fodor, philosopher of language Jerry Fodor, and the other is from the epistemologist Timothy Williamson. Okay, so Fodor and his colleagues published a paper in 1980 called Against Definitions. Right? And one of the points of this paper was basically to say that definitions of the sort that philosophers are interested in, that, as it were, draw the line in exactly the right place, haven't been forthcoming, and there is no prospect that they will turn up in the foreseeable future. Right. So the standard picture of definition is that the definition of a word makes explicit what is true of a thing if and only if the word applies to it. Right. So the definition of bachelor, right, it specifies what is true of a person if and only if the word applies to that person. But it turns out that even words like bachelor are problematic. Right? I mean, even coming up with a tight definition of bachelor turns out to be kind of tricky, right? I mean, so the standard definition of bachelor is an unmarried man, right? Well, okay, so an unmarried man who's been living with the same spouse for 20, 30, 40 years, but they never got married. Right? Most of us would hesitate to call such a person a bachelor. So, or is the Pope a bachelor? I mean, there's a whole lot of examples that people come up with in this context. And Timothy Williamson, in his book on knowledge and its limits, he draws out some of the implications of these problems with definition for attempts to define the concept of knowledge. Right? So Williamson describes the sort of terrible industry of philosophers trying to come up with bomb-proof definitions of knowledge, and each one proposing a definition only to then be refuted by a counterexample in the next issue of the same journal, and so it goes on. Right? And Williamson kind of draws the conclusion that the definitional project, at least in epistemology, is what he calls a degenerating research program. And that experience, I mean, the fact that definitions are constantly overturned confirms inductively the futility of the program. Okay, so now we've arrived at a kind of tricky position, right? So we've got this seesaw. We want to get off the definitional seesaw. We're looking for a perfect definition, but it looks as though it's going to be very hard to find one. Experience certainly confirms that it's going to be very hard to find a perfect definition of terrorism. But of course, if you say, well, let's just give up on the definitional project, of course, the lawyers will say to you, well, I'm sorry, but we actually do need a definition for legal purposes. We can't do Williamson and say, well, it's a degenerating research program, right? Maybe it is, right? But we actually need a definition. So I think we need a kind of approach to this problem. So I hope I've kind of identified what the issue is. Right? We need a certain kind of definition, which it seems we can't have. Right. But we can't abandon the project altogether either. We can't just say, well, let's just give up on this. So I think we need a different approach. And the approach that I recommend is what I call relaxed pessimism. So relaxed pessimism has these three dimensions. The first dimension is it's pessimistic, or as I would say, realistic about the quest for definitional perfection. I mean, it just takes it for granted, right, that you're not going to get a completely perfect definition. On the other hand, it regards the project of defining terrorism not as an abstract intellectual exercise, but as a pragmatic problem, as an exercise in pragmatic problem solving in the face of a threat. Right? So that's again from the Carlile report. Right? So what he's proposing is a kind of pragmatic approach to definition. And what I want to do is to spell out what a pragmatic approach to definition would look like in this case. Okay? And instead of aiming for perfection, what we should be aiming for is what I call a good enough definition of terrorism. Okay, so that's what I call relaxed pessimism. Okay, so let me just spell out this pragmatic approach. So the pragmatist's thought is something like this. We talk about terrorism because we take it that terrorism is a distinctive category of criminal activity. We take it that terrorism is not a crime like any other. So murdering to advance a political cause is a different kind of thing from murdering to advance a financial cause, or murdering to advance a romantic cause, whatever it is, right? So that's one thought, and the other thought is that terrorism is also a description of an action or a kind of action that triggers special powers. Right? So really, the point of trying to define terrorism is to understand the circumstances in which it's appropriate for there to be special powers to deal with a particular crime. Okay, so what are these special powers? So I'll give you some examples, right? So, the Terrorism Act gives the authorities the special power to charge people with terrorism and to detain them for up to 14 days. Now, that's much longer than the period for which they're allowed to detain people for non-terrorist offenses. Right? Because that's an example of a special power. There's the power to proscribe organizations, right? To ban organizations. That's another power. I mean, there's a whole long list of powers, right? Which you can easily look up if you're interested. So when you think about the definition of terrorism in that way, I think there are sort of two basic questions that need to be addressed. The first is what I call the distinctiveness test. That is, does the definition of terrorism in the Terrorism Act reflect the features of terrorism that distinguish it from other crimes? Okay, so whatever else the definition of terrorism does, it's got to distinguish terrorism from other kinds of crime. Right? If there is a distinction, then the definition must reflect that. And secondly, the definition of terrorism must aptly describe the type of crime for the prevention, detention, disruption, and investigation of which special powers may be used. Okay, so we need to think of it in that way. Think about the powers that the definition is connected with. And that, I think, suggests that that when you're assessing a particular definition, you really need to subject it to a kind of cost-benefit analysis. Right, so this is a way to make the project of defining terrorism a kind of practical project. Okay, so there are various practical purposes that are served by a definition of terrorism. So the practical purposes include the practical purposes of saying when it's appropriate for these special powers to kick in. But at the same time, we also need to bear in mind when you define terrorism, the need not to impose intolerable costs or burdens on the police or on counter-terrorists. Right? So if the broader your definition, the greater the burdens potentially on counter-terrorists. Right? So that's part of a cost-benefit analysis. And another part of the cost-benefit analysis would be, well, what's the impact of our definition on civil liberties? Right? Are we now defining terrorism so broadly that that terrorism laws could potentially be used to restrict civil liberties? So you think about the Davison case, right? The Davison case is interesting because that's an example of political protest that would fall under the Terrorism Act. So you might think, well, we should be careful about defining terrorism in such a way that what you might think of as just political protest, potentially counts as terrorism. Okay. So there are costs. There are costs in terms of civil liberties. There are burdens, that is to say, the burdens that a definition of terrorism places on the police and on counterterrorism. So instead of thinking of the definition of terrorism as a kind of abstract intellectual exercise where we trade intuitions about what is and what isn't terrorism, we should think in much more practical terms about the issue of special powers, about the resource implications of a particular definition, and about the impact on democracy and civil liberties. So the objective should be to come up with a definition that passes muster along these various different practical dimensions. Okay, so this is a very different way of proceeding from the way that philosophers sometimes proceed when they argue about definitions. Right, so one particularly fruitless way of arguing about definitions is for people in a philosophy seminar to trade their intuitions about whether something does or does not fall under a problematic concept. Here, we're not trading intuitions in that way. Right? I mean, intuitions come into this in an indirect way, but what we're looking at are the sort of practical implications of a definition, and we're trying to work out whether the practical implications of defining terrorism one way rather than another are practical implications that we can actually live with. However, it's also important to see that it isn't essential that every problematic case is dealt with by a clause in the law, right? So if you look at the Davison case, you might say, well, we don't want that to count as terrorism. But it's a further question whether you write in an exclusion for that kind of case in the law. I mean, another way of dealing with it is to say, well, okay, the Davison case could be prosecuted as terrorism, but that's not to say that it should be or that it would be. Right, so this is what's sometimes called the doctrine of discretion as protection. Right? So the prosecutors, of course, have discretion to prosecute for terrorism or not to prosecute. Right? And I mean, one thing in the UK that is interesting is that the convention among prosecutors is where you can prosecute someone for a non-terrorist crime. If there's a non-terrorist crime that's been committed, right, then by and large, that's what you should go for, right? Unless there's a real threat of harm that would be caused by not charging the person with terrorism. Okay, so the approach is in a way kind of quite informal, right? Which is to rely on the good sense of the authorities not to prosecute people for terrorism when it wouldn't be, as it were, the appropriate thing to do. And there are a great, the last 2 or 3 years, there are many examples of actions that could have been prosecuted as terrorism which weren't. Right? So if you think about, Just Stop Oil, for example, a number of their stunts could certainly be prosecuted under the Terrorism Act if the authorities were minded to do so. Right? I mean, there'd be serious damage to property, endangering the health and safety of the public, right? Designed to influence the government, advancing a political cause. All of those conditions are met, right? And yet they haven't been charged with terrorism. I mean, there are other offences under the Terrorism Act. So, I mean, it's an offence in the UK to encourage terrorism or to glorify it, right? Where glorifying it has the effect of encouraging it. Right? Well, again, I mean, I can think of lots of examples in the last 2 or 3 years of public events where people certainly have, in my view, been encouraging terrorism, but they haven't been prosecuted for it. Right? So there is this element of discretion, and I think the deep question here, which I can't really go into, is whether it's safe to just rely on discretion. What if a malign government comes in to power in the future that doesn't refrain from pursuing people, right, for terrorism, right, where it can do according to the letter of the law? But again, I mean, I can see that that's a serious concern, but you're not necessarily going to be able to deal with that just by adding additional clauses to the definition to rule out every possible problematic case. So at some point, there's going to have to be an element of discretion. Okay, so I now want to talk about the Southport mode. So Ben, how long have I got? Good. That's all I need. Yeah. So I want to now go back to the Southport case and reflect on that in the light of what I've been saying. So I think that there are kind of 3 responses to the Southport case which are on the table, and I want to just look at the sort of pros and cons of these 3 responses. Right, the first response is what I call the expansionist response, which is to expand the current definition of terrorism to allow violence for its own sake. In other words, not violence for the purpose of advancing a cause, but violence for its own sake, to allow that to count as terrorism. Right, so if you drop the 3rd limb of the definition, so it doesn't have to have the purpose of advancing a cause, that would then allow potentially that to count as terrorism. So that's expanding the definition by dropping one of the conditions. A second approach that you might have is to say, well, actually, maybe even the current definition of terrorism would have allowed or could allow the charge of terrorism in this case. I mean, the authorities determined that this wasn't terrorism according to the existing definition, but maybe that wasn't the right thing for the authorities to think of. So that's the second response. And the third response is to stick with the status quo, right? Just accept that it wasn't terrorism according to the existing law, and that's fine. We should just live with that fact. So looking at these 3 responses, I mean, the problem with the expansionist response is I mean, not surprisingly, that you're going to get a whole bunch of false positives. So here are some examples of false positives, right? So football hooliganism would potentially count as terrorism, right? So if two groups of football fans arrange to have a fight, right, and it's just violence for its own sake, right? They have arranged to have a fight because they just like to have fights, right? Well, we don't want that to count. We don't want that to count as terrorism. And yet, in a fight of that sort might indeed have caused serious injury to members of the public, and might indeed have even been designed to intimidate a section of the public. I mean, that doesn't look like it's the sort of case that should be counted as terrorism. Domestic violence would be another case. And if you think of terrorism in this way, then it looks as though we're sort of starting to lose any grip on what makes terrorism distinctive, right? So if domestic violence is terrorism, if football hooliganism is terrorism, we're starting to lose a sense of what makes terrorism a distinctive kind of crime. And of course, I could just imagine what people in counterterrorism would think if suddenly they have to worry about this, right? They've got enough on their plates without dealing with this sort of violence. What about the proposal that actually, well, maybe we should think of the Rudakubana case as a genuine case of terrorism? Now, this raises some really deep questions, which I don't really have the time to go into, but it would be very interesting to hear what you think about this, right? So the crucial question about him is, was he acting for the purpose of advancing a political, religious, ideological, or racial cause? Now, one thing that is worth noting, right, is that there is no limit. So here I'm quoting from the review that was published last week. There is no limit to the type of religion, politics, ideology, etc., that may underpin a cause. Right, so there are some interesting cases that are worth thinking about. So think about, the Joker in Batman. Right. So the Joker's sort of objective is to advance the cause of evil in the world, right? So the Joker just wants to do malign things because that's his ideology. So would that count as, would the actions of someone like that count as for the purpose of advancing an ideological cause? Would that be an ideological cause, a religious cause? Right, Satan is. I mean, another interesting development recently, so there are people now who subscribe to what the ideology of what they call no lives matter, right? And they're into sort of, you know, basically violence for its own sake, right? I mean, that would be another interesting case. So one question about Rudakubana is that well, maybe in some sense, actually, there was a kind of ideology. I mean, another interesting example, the Rudakubana case made me reread Anthony Burgess's novel, A Clockwork Orange. Right, so if you think about A Clockwork Orange, right, so you have this group of teenagers whose idea of fun is to go out in the evening and carry out some ultra violence, right? Well, you know, you could say these are just random acts of violence, but there's also a kind of vision there, right? A vision of how these boys want to live their lives, what their vision of the good life, you might say, right? So, well, why not think of that as a kind of ideology, right? Well, I mean, I haven't spoken to Rudakubana, as you can gather, so I don't know. I mean, I don't know, but I think even if you were convinced that there was a kind of ideology or a project or a vision there, right, it would be a further question whether he was acting for the purpose of advancing that project or vision, whether it would count as acting for the purpose of advancing a cause. Now, this is an issue that I think is not really addressed anywhere, which is, what is it to have a cause? That's one thing. What counts as having a cause? And what is it to act for the purpose of advancing the cause? What are the conditions that need to be fulfilled for you to be acting for the purpose of advancing a cause? It's not enough that you have one. So one interesting idea in the report that was published last week was the idea of a knock-on effect, right? That you're only acting for the purpose of advancing a cause if you believe and intend that your action has a certain knock-on effect. Right, and that knock-on effect being the effect of advancing the cause, whatever the cause is. Right, so there are some very, very tricky questions here. I don't completely rule out this response, but it does raise some difficult questions. So that leaves a third response, which is just to leave things as they are, right? Which is just to take the Southport case as a kind of awkward case, right? But actually to draw the conclusion that, well, if you do your cost-benefit analysis and think through the consequences of changing the definition to accommodate this, the conclusion you will probably come to, you should come to, is that actually we shouldn't change the definition, right? Because it's going to just cause far more. It might help with this case, but it's just going to unleash a whole mass of difficulties on other fronts. And indeed, the conclusion of the report that was published last week, which I agree with, is that the definition of terrorism should be left as it is. However, what the report does recommend is the creation of a new offence, which is the offence of planning a mass casualty attack. Right? So to make that an offence. And planning is understood as involving preparatory conduct. Right. So there doesn't have to be an ideological cause. Just planning a mass casualty attack is itself an offence. Mass casualty means more than one person. So that's a very interesting idea, which would have got Rudakubana, right? Because he clearly was planning a mass casualty attack. But that again is raises all sorts of interesting questions, which is what counts as planning, right? Well, how do we understand the notion of planning? What counts as preparatory conduct? Okay, so I just want to end with the following thought, right? So I'm not here to kind of defend a particular response to the Southport case, although you'll gather that my sympathies are pretty much with the conservative response, but more to use this talk really as a way to reflect on the whole project of defining terms like terrorism. right? And I think what has emerged from this discussion is the importance of thinking of the definitional project in very practical terms, right? Very practical terms, to think about what it means in practice to define terrorism one way rather than another. And I think that's it. And it will be interesting to think about applying that view of definition more broadly in philosophy and seeing where we get to. Okay, that's it.
So, our respondent this evening is Dr. Lilith Mace of the University of Glasgow. Dr. Mace is a research fellow on the project Knowledge Lab, Knowledge First Social Epistemology, which is funded by a grant from the European Research Council. She is a graduate of the universities of Glasgow and Oxford and Edinburgh. Dr. Mace publishes on various topics in epistemology, including the right way to respond to risk, the nature of doubt, and the norms that govern doubt. More generally, her current work is developing a comprehensive account of doubt by thinking about the role that it plays for us in our inquiries and about the attitudes that characterize inquiry more broadly, like curiosity and wonder. We're very grateful indeed to Dr. Mace for being the Stevenson Trust's respondent for Professor Kassam's lecture. Please welcome her warmly.
Thanks very much for that, Ben, and thank you, Professor Kassam, for that fantastic lecture. In this lecture, Professor Kassam has raised the question of how we should define terrorism. Kassam argues that, rather than trying to strictly define terrorism by articulating conditions that are true of an act, if and only if that act is an act of terrorism, we should instead aim only for a good enough definition of terrorism. A good enough definition will specify conditions that hold for the most part, but which may not apply to all and only those acts that we want to call acts of terrorism. A good enough definition will tolerate some discrepancy between our pre-theoretical judgments about whether a given act is a terrorist act and the verdict issued by the account, provided that there's significant practical or theoretical benefit to understanding terrorism as the account would have it. In particular, Kassam holds that a good enough definition must be useful for counterterrorism purposes. And this will require that the definition captures the most common, or perhaps better, the most salient kinds of terrorist acts under its purview. However, it can't class too many acts as terrorist acts, as this would overwhelm our already overstretched counterterrorism forces. The move away from providing strict definitions to good enough definitions can be seen as part of a broader movement in philosophy, which sometimes goes by the name of conceptual engineering. Conceptual engineering is a method for answering what is X questions that isn't solely or even primarily concerned with what competent speakers mean or understand by the term X. Rather, conceptual engineers are concerned with what our terms should mean, given our legitimate practical or theoretical goals. As such, we might change the meaning of X if doing so would better serve those goals. So, for example, a conceptual engineer who's interested in the question, what is a woman, won't begin her inquiry by surveying ordinary use of the woman, asking competent English speakers what they understand by the term woman, and so on. Rather, she'll begin by articulating some theoretical or practical goal that she has, for example, the feminist goal of advancing the rights of women, and then she'll articulate conditions for someone's being a woman that are most helpful for that practical goal. There's a well-known objection to this way of doing philosophy, first raised by Peter Strawson in the 1960s. If I ask you about some worldly phenomenon X, for example, I ask you what X is, and you respond by redefining the term X so it no longer picks out just that thing in the world, haven't you just changed the subject? We're no longer talking about the very same thing in the world in which I was interested. Rather, we're talking about something else. Whatever you tell me using your newly defined term X, you won't be telling me anything about the thing in the world that I asked about. The first point I'd like to raise for consideration is the worry whether this good enough definition of terrorism, or indeed any good enough definition of terrorism, is going to be vulnerable to just this objection. We want to answer the question, what is terrorism? Terrorism is a worldly phenomenon, and we want to understand it better. Suppose we try to answer this question by giving a good enough definition of terrorism, a definition which is true of most, but not all, of the acts which we pre-theoretically class as terrorist or non-terrorist. In that case, haven't we simply changed the subject? We're no longer talking about the very same thing with which we were interested, namely the worldly phenomenon of terrorism. Rather, we're talking about something else, something very similar, certainly, but something else to the phenomenon with which we were first interested. But if that's right, have we shed light on the phenomenon of concern? That is to say, have we shed any light on the phenomenon of terrorism? The second point I'd like to raise has to do with the treatment of false positives and false negatives. As Kassam points out, too strict an account of terrorism, one which posits conditions which are too hard to satisfy, will generate false negatives, cases which intuitively should count as terrorism, but which the theory does not count as such. In contrast, too weak an account, one which is too easy to satisfy, will generate false positives, cases which intuitively are not terrorism, but which the theory judges to be. As a good enough definition doesn't try to strictly define terrorism, it's no objection to one just that it generates false positives or false negatives. Nevertheless, for a good enough definition to be good enough, it must be that any false negatives or positives it generates are not too implausible. For example, if a good enough definition of terrorism issued the verdict that 9/11 is not a terrorist act, this false negative would be simply too implausible for us to accept the account. The issue of whether to prioritize avoiding false positives by having a stricter theory or false negatives by having a laxer theory is known in philosophy as the problem of inductive risk. As Kassam points out, this is a practical problem, but more than a practical problem, it's also a value-laden one. The philosopher of science, Heather Douglas, argues that we can't solve the problem of inductive risk without appealing to our values, to what matters to us. For example, scientists might test whether a certain chemical causes cancer by seeing whether lab rats exposed to the chemical are significantly more likely to develop cancer than a control group. But whether a difference between the groups is counted by the scientists as significant will depend on whether the scientists prioritize avoiding false negatives or avoiding false positives. So in this case, a false positive will be a finding that the chemical does cause cancer when it in fact does not, while a false negative would be a finding that the chemical does not cause cancer when it does. A laxer standard for significance is more likely to generate false positives. In turn, this may lead to overregulation of the industries that produce the chemical. In contrast, a weaker standard for significance is more likely to generate false negatives, and this in turn may lead to damage to public health. So in deciding whether to use a laxer or stricter standard for significance, the scientist must consider whether they care more about avoiding unnecessary regulation to industry or avoiding damage to public health. In constructing a good enough definition of terrorism, we'll have to make the same value judgment. Should we care more about avoiding false positives, i.e. labeling acts as terrorist when intuitively they're not, or false negatives, failing to label an act as terrorist when intuitively it is? On the face of it, the latter kind of error might seem clearly worse. It would be disastrous if endorsing our good enough definition of terrorism left counter-terrorist forces unable to investigate, charge, and prosecute terrorist acts as terrorist acts. However, as Kassam has drawn our attention to, there are competing concerns here. In particular, we might think that avoiding false negatives by imposing a laxer standard for an act to count as terrorist might lead to direct action by activist groups such as XR Rebellion or Just Stop Oil being labeled as terrorist. And again, as Kassam points out, these groups do engage in property damage with the goal of shifting public opinion on how urgently we need, and political opinion on how urgently we need to deal with climate change, which may already count as terrorist on the UK's definition. Classifying direct action as terrorism is very likely to have a chilling effect on freedom of expression. If would-be protesters can reasonably expect to be investigated, prosecuted, or charged as terrorists for engaging in direct action, many simply won't take the chance. They'll stifle their right to protest in order to protect their safety. So the second point I'd like to raise is to emphasize that in considering how to balance the risk of false negatives against false positives, we must carefully reflect on our values. Is it more important to us to protect the general safety of the public by making sure that every terrorist act will be classed as terrorist by our definition, or to preserve the rights of all by making sure that no non-terrorist act is classed as such by our account? We can't articulate a good enough definition of terrorism without answering these questions for ourselves. So to sum up, the 2 points I'd like to raise for consideration are: first, the worry whether any good enough definition of terrorism is vulnerable to this changing the subject objection. And second, to emphasize that the project of giving a good enough definition of terrorism is value-laden from its very beginning. I hope these points can helpfully guide our discussion of this crucial and careful piece of philosophical work from Professor Kassam.
Okay, folks, we have a little time for questions now. My colleague Robert's going to keep an eye online. I'm going to keep an eye on the room. Perhaps if you could kick off and then keep your hands up if you want to ask one, and I'll construct a bit of a queue. Over there first, gentleman with the glasses and the beard, please.
Thank you. Thank you for the talk. I really enjoyed it and like the kind of neutrality, even if I would have been less kind for the Prime Minister. I was just surprised by the framing, because it seems to me that it could be even more neutral. So, because if you are really pragmatic in the approach, you can also think, okay, the framing should be, should we even need a definition? Because you might think that, the costs are so high, there is no need to pay for them, that we don't actually need any special powers, as you were mentioning, to deal with these problems. So that the more neutral setup would be, just let us start by asking the question if we even need such special laws and special powers.
Okay, well, thank you. So I think there are a number of different elements to that. Right? So one suggestion which has been made is that actually there just shouldn't be such an offense as terrorism at all, right? Because most acts of terrorism, if not all of them, are crimes anyway, right? So if it's murder, it's murder. Whether it's terrorist murder or another kind of murder, the person could still be prosecuted for that, as was the case in Southport, right, where he was found guilty of murder and sentenced for murder. Okay, so that's one. I think one interesting question, and the answer to that question depends on these two things. One is there enough that is distinctive about what we call terrorist crimes to merit a separate designation in the law? So does the fact that these are crimes for the purpose of advancing a political, religious, racial, or ideological cause give them sufficient distinctiveness to merit a special label under the law? And the second question is the question about special powers, which you raised, right? Now, as for whether we need special powers to investigate these crimes or not, I mean, that I think is a kind of empirical question, right? So if you take, for example, the power to detain suspects without charge for 14 days, it used to be 28 days. Now it's been reduced to 14 days. Right? So if you were to say, well, look, no, we don't need special powers. We should just have only 3 days or 4 days or whatever the usual amount is for investigating these crimes. One question would be, well, why not, right? Well, what's wrong with that? Why do we need these special powers? And the answer to that is an empirical question. And I think that the answer that actually many counter-terrorists will give you is that in a lot of these cases, it's very unclear what we're dealing with. So one of the things that needs to be done in investigating these crimes is looking at their internet search histories and looking at what they text messages, and a lot of this stuff is encrypted, right? So actually, just getting around the encryption in and of itself takes quite a long time. Right, so there would be practical considerations like that. Now, whether that justifies 14 days, 28 days, or any particular number of days, that's a question that would need to be kind of negotiated with the people whose job it is to actually investigate these crimes. So, I mean, my own view is that there is enough that's distinctive. I think that acts for the purpose of advancing a cause of these various kinds are distinct, sufficiently different from mere crimes to merit a kind of special label. And I'm also persuaded that some special powers for the investigation of terrorist crimes are going to be necessary because of the special features of these crimes. Whether the existing menu of special powers is quite the right menu or not, that I think is a matter for further debate.
Thank you. Michael Fraser is next.
Thank you. Well, thank you for taking my question, and that allows me to do a follow-up, right? Because I was quite struck that as is so often the case, there's a kind of horseshoe, and the conservative can very quickly become a radical. And all the reasons for not being disturbed that the Rudakubana case was not classified as a case of terrorism are reasons to doubt that we need a classification of terrorism at all. Certainly in the law, we may continue to use it as a cultural category. And I guess I was wondering if, based on your response to that, if you're correct that there are certain special crimes that require these special powers, why should we think, and this relates to the changing the subject objection, that pragmatic question of what are the special crimes that require the special powers should bear any relation to our ordinary language or intuitive sense of what counts as terrorism? Wouldn't it be more useful to have the special crimes category, the crimes necessitating special powers category, and then have legislation on that, and add or subtract different kinds of crimes as they emerge when necessary to do what is most effective in terms of dealing with that particularly important category? And if we're concerned about whether or not that pragmatic category maps on to what we intuitively consider terrorism, then we're concerned with the wrong thing. And in fact, we should just bite the bullet. We are changing the subject. And of course, we should change the subject if changing the subject produces the pragmatically best results.
Yeah. Okay. So just starting off with what you said about the Rudakubana case, right? The reasons for not worrying about whether that's terrorism or not are reasons for not worrying more generally about whether something is classified as terrorism or not. I don't really see that. I mean, the reasons for not worrying about the Rudakubana case are that here's a case that has certain features which might be thought of as features of terrorist acts, but which in fact in this case turn out not to be so. Right? So you might look at this and think it looks like terrorism, but actually this looks like it's something very very different from the 7/7 bombings in London. Right? So then if you look at something like the 7/7 bombings in London, I mean, you could say, well, why do we need to prosecute that as terrorism? I mean, we could have just, if we'd apprehended those the people that hadn't killed themselves, well, we could have just charged them with mass murder. Of course, that would be an option. That would be an option. But I think that if you're thinking about the project of investigating and prosecuting and deterring people from carrying out acts of that sort, you need to be clear what that sort means. right? Now that, if you say, well, that sort just means killing lots of people, that doesn't do justice to what the sort is, right? Because it is absolutely fundamental to the 7/7 bombings, and indeed to many cases of terrorism, that they're framed very much in terms of the mission of advancing a particular ideological, religious, or racial cause. And if you simply just as it were, just registered that as a kind of interesting fact about these rather than constitutive, I think you're missing out something kind of really fundamental about this. On the special powers point, I mean, it's just worth pointing out that terrorism is not the only crime for the investigation of which there are special powers. I mean, there are other categories of crime. Fraud is another example where there are special powers. And again, I can't emphasize this enough. I don't think that these questions about whether we need special powers, and if so, what they are questions that can be resolved from the comfort of one's armchair. I mean, I think these are questions that need to be hammered out and negotiated with people whose job it is to investigate these crimes, right? And they will very, very often make the case for extensive special powers, and legislatures, including the British Parliament, push back against that and say, no, you don't. So it was originally 28 days, and a lot of people felt very uncomfortable, right, about the idea that you could hold someone for 28 days without charge whilst you are investigating it, right? But it's not a choice between 28 days and nothing, right, or treating them like every other criminal. It's a matter of negotiation and debate and discussion, and you need to come up with a kind of a practical solution to a practical problem. And I think that the idea that there's nothing distinctive about these crimes, sufficiently distinctive to merit classification as terrorism, well, that is a view. I mean, that is a view, and I think it's a view that's worth taking seriously. But to go back to the 7/7 case, or 9/11, or any of these examples, you are missing something very important, right, about the drivers of this kind of crime, which are the things that counter-terrorists need to be addressing.
Fiona, please.
Thank you very much. You said that we should move away from philosophers defining terrorism because it's a degenerative research program. All we're doing is trading of intuitions. And then we should move towards this practically defining terrorism where we look to avoid burdens and preserve rights. However, I can't see why that definition and that process just doesn't end up trading intuitions. Like, does this preserve civil rights enough? Does this do cases of a certain sort that we outline just give too many burdens to the police and so on? So I can't really see that there's a practical solution here. We're just we should just define terrorism, as Lilith perhaps suggested, to best capture the concept of it. And when we want to put it into law and act on the basis of it, then maybe we need to have maybe a separate definition, but or maybe we in the first place come up with what we call a practical definition. But it's going to be this, all of these solutions are going to have this practical problem of trading intuitions about what counts for what purpose.
Yeah, so actually here I think I want to draw on the response, right? So what you're calling trading intuitions, I think Lilith was describing using that concept of a value, right? So I think it's certainly true that there are disagreements about values that underpin debates about how terrorism should be defined. And those, I mean, I don't find it particularly compelling to conceptualize those as, disagreements about intuitions. I mean, I think there are sort of fundamental values that people have, and for which they make a case for, and which really come into focus in these debates about the definition of terrorism. So there's also the question of, I mean, a word I'm going back to the response. I mean, there are values, but there are also priorities, right? I mean, so there's also what are our priorities in a given political historical context? What is the threat that what are we worrying about, right? So the definition needs to not only, as it were, be reflective of a set of values that we're sort of we're happy with, but it's also got to be sensitive to the particular threats that we're confronting, and to have a sort of sense of what's prior to what. Now, one could say, yeah, but that's just a fancy way of talking about, intuitions, right? Well, if that's what's meant by intuition, then that's fine, right? I don't really have any problem with that. But if you're thinking about, the trading of intuitions about, Gettier cases, for example, of course, I can give you a case and say, well, in this case, I think S knows that P, and you can say, well, I don't have that intuition. Those debates don't seem to me to be debates about fundamental values, particularly political values, democratic values, in the way that these debates about the definition of terrorism, really are. Right? I mean, I think that's the difference between between the two cases. I think it'd be much more fruitful to think about debates about knowledge as again in sort of practical, in practical terms, right? So if you say, well, what did the president know and when did he know it, right? Well, what are the implications for different views of knowledge for answering that question? Right? So I'm not suggesting that you can sort of escape all appeal to intuition. Maybe all thinking, assessing arguments involves intuition at some level. But I what I liked about the response was the highlighting of this issue of what's really at stake here, right? And in terms of fundamental political values.
Taking a question from Zoom next. I'll keep building my queue in the room.
So we've got a question here where they ask, what is the rationale for seeking to exclude Emily Davison from the definitions of terrorism, especially in view of the suffragettes movement embracing of violent means, including bombing campaigns, in support of their cause? Is there an intrinsic implication trying to make here that we should label as terrorism only violence made instrumental for causes with which we disagree?
Well, that's a really excellent question, right? So I think what I would say is the following: that there actually is there is a case. I mean, that you could make a case that some of what the suffragettes did was indeed terrorism. What the questioner referred to was bombings, right? So I don't have any problems with classifying that as terrorism. The case against classifying what Emily Davison did as terrorism is the following: that if that is prosecuted as terrorism, then a large category of political protest is going to be classified as terrorism. Right? Now, this is where you get to the question of values. Are we happy with that? I mean, is that okay? Right. So would we? I mean, if what Davison did was terrorism, that, as I said, a lot of so-called civil resistance is terrorism. Right. So civil resistance would include the stuff that's done by Extinction Rebellion and Just Stop Oil and so on. And this is where we really kind of get to the question of values, right? I mean, do we want to live in a society where that kind of protest, political protest, or that kind of political action is prosecuted as terrorism? And the answer may not be obvious. I'll give you a really current example. I mean, much more current than Emily Davison, right? So in America at the moment, as I understand it, there is now a campaign of people, of political activists, destroying Tesla charging stations, right? So they're destroying Tesla charging stations. They're setting fire to Teslas and vandalizing them, right? Now, if you say, well, okay, so does this meet the definition of terrorism? Well, serious damage to property. Yeah, you destroy a complete charging station. That seems like serious damage to property. Designed to influence the government or a section of the public. Well, it was certainly designed to intimidate a section of the public, namely Tesla owners, right? And for the purpose of advancing a political cause, well, yeah, right. I mean, it's the anti-Trump, anti-Musk political cause, right? So that, again, looks like it just ticks all the boxes for terrorism, right? So I mean, the question I would ask the questioner is, well, should that be prosecuted as terrorism or not? And I think if the point of the question is that, well, the answer you give to that is going to depend upon sort of what you think of Musk and what you think of, what you think of the political cause. I mean, I think that is actually what would happen in many cases. But I would hope that in cases like that, we err on the side of not prosecuting that sort of action as terrorism, particularly because there are lots of other things we could prosecute them for that would be somewhat less explosive, like criminal damage, for example.
Gentleman with the dark hair and the glasses here, please, Chris.
Thanks very much. Aziz from the School of Law here in Glasgow. I have a suggestion. Maybe you've ruled it out already, but from the definition that you started with, couldn't we imagine slimming some of the criteria, especially specifying the intent of spreading terror? So it's not about committing violence, and it's not about necessarily having an ideology, but it's about the risk or the threat of spreading terror, so that we keep something distinctive of terrorism,
Mm-hmm.
but at the same time, we don't attach it to a too substantive approach. And by the same token, maybe include the effects and potentially the powers that may be justified in order to respond to that. So it's specifying the intent. So for example, that in my view would clarify that Extinction Rebellion are not terrorists. The Southport terrorist, I wouldn't conclude, because I don't know whether there was an intent to terrorize. But if there isn't, maybe if it's just about murdering, you wouldn't count as terrorist. I don't know if that helps.
No, it does help. I mean, that's so just to be clear, so the proposal is if somebody acts with the intention to terrorize at least one other person, but that there is no ideological, racial, political motive other than well, whatever motivates them to commit an act of terrorizing. I mean, so the worry about that is that it's going to count as terrorism acts of hooliganism, for example, right? Which may well be intended to. I mean, if you've been to a football ground where you have fights breaking out, I mean, you could argue there's an intent to terrorize in that case, to terrorize the other fans, right? So it's quite it's going to give you that sort of case as terrorism, and that seems, at least on the face of it, problematic. On the other side, I mean, you are then going to be confronted with cases like what is called cyber terrorism, right? Now, I mean, that's worth thinking more about whether actually the label cyber terrorism is the right label, right? I mean, maybe we shouldn't call it terrorism, partly for the reasons that you gave. So it seems to me that what you're latching onto is something that is important in many cases. In many cases of terrorism, but I'm slightly reluctant to make it, definitive for the reasons that I've just given.
John Curtis.
Thank you. I should say I'm a non-philosopher. This partly follows up what you've been saying. I think one of the things you didn't discuss is the fact that probably what the law has to do is it has to define what an individual act is and whether or not it is to do with terrorism or not. But isn't the whole point about terrorism, and essential to certainly an intuitive understanding of the concept, is that it's something whereby you're doing something whereby the implication is if you don't change government policy or your behavior, whatever, it will happen again.
Yeah.
In other words, terrorism is not an individual act. It is a potentially repeated act, and that's point one. And that, therefore, again, this is why then the two cases you've used to headline your talk, we can look at them and in some sense and say, well, these are individuals engaging in a one-off act. But that actually, if terrorism is about repeated actions.
Mhm.
It almost by definition implies collective action
Yeah.
and collective planning. Because if individuals who commit an individual crime end up being prosecuted, there are others who are going to follow up, who are going to repeat it. And that, of course, then also means this is why, because the element of conspiracy seems to be essential, why the idea of counterterrorism matters, because you're hoping to capture the conspiracy before the acts of terrorism take place. So I wonder if we need to think much more about this as collective, both in the sense of the origins of the endeavor, but also the character of the events. One-off events in the end cannot really be adequately defined as being terrorism or not.
Well, that's very interesting, right? So one thing that people are worrying about a lot nowadays is so-called lone wolf terrorism, right? So these are individuals who are not part of any organization. They're not part of any systematic campaign of terror, right? And supposing that the mission of the lone wolf terrorist is simply to detonate a suicide bomb, right? And supposing that they do indeed do so. Now, in the nature of the case, it's a one-off act for them, right? Now, if they carried out the suicide bombing under instructions from a political organization that has a whole campaign of suicide bombing, like Hamas did in the early 2000s, then it wouldn't be a one-off act, right? But there are also these other cases which seem to be genuinely one-off. The other thing that you started off with was very interesting. This idea that the terrorist is saying, if you don't do X, bad things will follow, right? That's the terror bit. And so one interesting kind of version of that is the case of mafia intimidation, right? So if you think about how mafia intimidation works, it's exactly like that, right? I mean, in that case, I take it that it's for the purpose of advancing a financial cause, right? In the case of the mafia. Now, again, I mean, I was reading an account in an Italian newspaper report of a police officer in Italy describing the mafia as terrorists, right? So, I mean, you could do that, right? But on the other hand, going back to the point about what are the sort of distinctive features of terrorism, as I was understanding it, I mean, the thought would be that, well, the mafia, it's still ordinary crime in the sense that the objective is to make, there's a kind of financial aim here, and they just using intimidation as perhaps even a campaign of intimidation as a way of advancing their financial interests. And that seems sort of rather different from, as it were, what Hamas was doing, right? Which was a campaign of intimidation, but not just to advance their financial interests, but to advance a political cause.
Sorry, forgive me, John. I ought to. I could understand the desire to push it on, but I think we need to wrap up. So, thank you so much. And I'm very sorry to the people who are still on the queue that I didn't manage to get to. I take it that their existence both in the room and on Zoom is a testament to the great interest of the talk we've had today. So I hope you've enjoyed it as much as I have. I have a couple of announcements before we thank our speakers once more. The first is, if you want to stay informed about Stevenson Trust's wide range of events like this, you can sign up for the mailing list on the website. And the website is also a treasure trove of materials, including recordings of previous Knowles lectures, if you want to have a little more of this type of thing. If your appetite for philosophy specifically has been whetted, then this is the first of 3 public events that we're running in Glasgow to mark the first ever British philosophy fortnight, coordinated by the British Philosophical Association. So if you've got the bug, there's a lecture tomorrow, public lecture by Alison Fernandez, who's going to be talking about chance as a guide to life. And then next Tuesday, that's the 25th of March, there'll be a lecture by Jesper Kallestrup called Why Demagogues Lie. You can find more about those and sign up via Eventbrite if you look for the philosophy department's website. Those 2 big pieces of business out of the way, it only remains really for me to wish you all a very good evening and to ask you once more to thank Professor Kassam and Dr. Mace for their extremely stimulating talks. Thank you.
Oh, good.
We had a nice message through on Zoom from a member of his family. So one of his daughters. You were